Yes, same difference.
Thank you so much. Welcome her.
All right, good morning.
Good morning.
All right, I'm delighted to be here. As been indicated, my name is Brandy Estelle. I'm a practicing attorney here in Southern California, throughout California as needed, from the law firm of Estelle and Kennedy, a professional law corporations. And I'll tell you a little bit of background. We're a full-service law corporation. We've got some flyers in the back that indicate all of our practice areas. We practice a number of areas outside of bankruptcy and tax. Other than that, we have a number of attorneys that pretty much cover the entire gamut. Between our lawyers, we have over 55 years of collective experience, and we've got 3 offices. Los Angeles and Upland are our physical offices, and we have a satellite office in Mission Viejo by appointment only. We started in 2001, where my partner, Attorney Kennedy, founded a father's rights organization called Child Support Liberation, where he focused on child support and providing a quality legal service at a reasonable price, and he dealt with custody, visitation, and paternity issues. He did that until we merged in 2012. Myself, in 2001, I founded the law offices of Brandy Estelle. I was a solo practitioner in private practice for 12 years and practiced in other areas. That's kind of where I got the whole full service idea. Clients were coming in from different areas, and what I found was that if I focus on one, I'm less able to serve the community in a larger range of clients. In 2005, I opened the doors of Creative Vision Investments, which is a real estate company that I'm the broker of, located here in Beverly Hills, which is why I'm a member of this Beverly Hills Greater Los Angeles Association of Realtors as well. And in 2012, Child Support Liberation and the law offices of Brandy Estelle merged. That's how we came up with the Estelle and Kennedy Professional Law Corporation. We're a boutique law firm in the community, and we have 7 attorneys, 3 paralegals, and 2 law clerks between our 3 offices. Today I want to talk to you about 5 things every landlord needs to know. One of the things that I've seen to keep us strong as business owners or business individuals is that I have a strong desire to learn and also spread knowledge and also master the practice of law. Laws change regularly, frequently, and the practice of law itself is constantly changing. It's interesting, and I'm never bored. I love this. I do these seminars to kind of attempt to make either ourselves more successful or provide information that you can give to your clients so that they can be successful as landlords as well. So I want to talk about some key things that may be helpful to you or your clients. If I do mention something that you know already, just humor me. If I'm able to present some new ideas, great. If I'm able to remind you of some fundamental principles that you already know, I'll call this presentation a success. Okay, the first area is local legislation. I always recommend that when you're in the business of real estate, you're aware of what's going on legally around you. Be aware, be involved, and know what's going on in the community that you're serving. Be the community that you reside in. It could be the community that you're serving. But talk to other landlords. Knowledge is power, and there's no need to reinvent the wheel, or at least that's how I look at it. Be involved in groups like this committee. If we aren't involved, we leave it to others to make change for us. And that change can negatively affect us, and we will not even have been involved. 64% of LA residents are renters. It's a large group. For example, over the last year alone, landlords and property owners had to deal with the battle to defeat the lack of a parcel tax notice to property owners. That was some major legislation. Landlords landlords and property owners were involved in defeating a transfer tax increase in Santa Monica. Landlords and property owners were involved with having to deal with defeating a $75 per transaction recording fee for all real estate transactions. These are huge legislative changes that have a direct impact on the work that we do every day. Be involved. We want to ensure that if there are laws that are put out there that are adverse to landlord interests, that they don't make their way into being enacted. And the way that you do that is being knowledgeable about local legislation and being involved in it. Rent control basics. This primarily is more of a residential concern, but I think it's something that if you're a landlord, you just need to know about. Rent control, what is it? It's also known as a rent stabilization ordinance. It's LA Municipal Code Section 15, also called RSO. It's a group of laws that limits the amount and the number of times a landlord can raise rents each year, and it limits or prohibits notices to vacate and terminate tenancies. Increases are generally based on the Consumer Price Index, and the terminations of tenancy reasons vary by city ordinances. Which cities in LA County have rent control? Los Angeles, Beverly Hills, Santa Monica, and West Hollywood. So that landlord is going to need to know if their property is covered with it and comply with those laws that were enacted under the municipal code. What does it cover? It covers all properties, 2 or more units built prior to 1978, all single-family homes, and anything with 2 or more units built after 1978 are excluded. A neat fact is that 80% of the 880,581 multifamily units in the city of Los Angeles are covered by rent control. I never knew it was that many. Why do we need to know it? So we don't violate the rules. There's more hassle and litigation if you're reported to the housing department, and there can be fines, and you can also be subject to little civil lawsuits. Good for me, bad for you. Resources. The best resources for the rent stabilization ordinance laws, I think, is the LA Housing Department website, and also a qualified real estate attorney, of course. Eviction notices. What eviction notices do you serve? There are, depends on your tenant, different notices must be sent. There's 3-day notice to pay rent or quit. There's a 3-day notice to perform covenants or quit. There's a 3-day notice to quit, a 30-day notice to quit, 60-day notice to quit, and also a 90 as well. Your 3 days, actually, let me just sum them all up. You must serve, the terms of your notices must comply with the law in order for them to be valid in a civil court if you need to proceed with an eviction. It's extremely important to make sure that you have the right content in your notices, and it's extremely important to make sure that you have served the notice in the proper way. I've seen a number of times in my unlawful detainer actions where, sadly, I'm watching and a landlord represented themselves, and they failed to, write the amount, the total amount that was due, a breakdown of what was unpaid in the rent. So the notice was therefore improper. And once they went in front of the judge looked at the notice, and in less than a minute, the case was dismissed because the notice was prepared improperly. Service is another key. Service is another key with the notices. 3 ways to serve any notice are personal service, substituted service, and by posting and mailing. Obviously, the best type of service is personal service. That's when you physically hand a legal document to the individual who is being sued or going to be sued. There is substituted service. You can serve that person at their place of residence, or you can serve them at their place of residence, or you can serve anyone over the age of 18 who's also at the residence. And then there's posting and mailing. So that would require you either nailing or basically affixing the notice itself or the legal document itself on the door, and you would also need to serve it by mail as well. If you're able to accomplish one of those ways to serve, your proof of service requirement will be satisfied. A fourth area that I think is very important for landlords to know would be the difference between stipulated judgments versus contested trials. And this area itself, in terms of litigation, I could present, for an hour on. Maybe Ben will invite me back and we can talk more about the details of litigation. But stipulated judgments versus contested trials, I call it the best kept secret, the stipulated judgments, that is. I call it the best kept secret because many people don't know of this option that has a number of benefits, and it's an alternative to leaving the outcome of an unlawful detainer action up to the judge to decide. Let's talk about how you get the opportunity to even prepare a stipulated judgment. Steps to file your unlawful detainer. Before you get to the stipulated judgment, you need to file your unlawful detainer. So let's go over some of those steps. There's three main forms for an unlawful detainer. There's a civil case cover sheet, a summons, and a complaint. You file those forms with the court, or you hire an attorney to do so. You have to complete the proper process service. You can use the same methods that we referred to when we discussed the notices. And once the tenant is served, then you wait for the tenant to respond. If they're served in person, they have 5 days, and depending on the other types of substituted service, there's different time frames in which they have to respond. If they don't respond, you can file a default action. Again, we can go over default actions in detail in another presentation. But if they do file a response, then it's the burden of the plaintiff, who's the landlord, to actually file another document with the court to even get a trial date or a court hearing. So let's talk about your contested hearing. So you have the hearing. Everybody has a right to a hearing when you're a plaintiff in a lawsuit. The court makes you, when you get to the hearing, you'll check in with the court clerk, and the court's going to make you go outside and negotiate with the defendant, with the other party in the action. There's a meet and confer requirement under the California Code of Civil Procedure that actually has the purpose of trying to preserve court time. So in the interest of judicial economy, the court says, I'm not going to hear your case until you go outside and you make an appreciable effort to try to resolve this matter. So you wait. If you are meeting and conferring, you take as much time as you need. But there are usually more than 30 cases on the court calendar on any given day. It's usually an average of about 50. So when you're at your contested hearing, you're often waiting anywhere between 1 and 7 hours. And I say 1 hour if you're leaning toward the stipulated judgment option, and I say 7 if you're leaning toward proceeding with the contested trial, which is you presenting your case in front of the judge. So with the judge, after your wait, again, whether it's 1 to 7 hours, both sides present their case. They can present written documentary evidence. They can present witness testimony. And the burden of proof, however, is on the plaintiff to convince the judge with the preponderance of the evidence. So the burden is on the landlord to produce the evidence. The tenant doesn't have to produce any evidence. The tenant may decide to produce a defense or to produce some evidence to support a claim or a defense that they may have. But the burden is on the landlords. The duty is going to be on you or on your clients to prove to the judge why you should win their case. I've seen many cases where someone thinks that they have a great case. They represent themselves, they lose. You think you have a great case, but when presented in front of the court, a lot of the things that we think that the judge may be looking for may be completely different than what the judge is actually looking for. The same procedural issue we discussed. If your notice is served wrong, the court's going to look at that notice, and if they can dismiss your case, they're going to try to do it as quickly as possible. Given the fact that there's such a large number of cases, the courts are looking for reasons for you to either resolve your case on your own or for them to get your case off their docket. Unfortunately, it's a misnomer that you get to go to court and you have, 5 days to tell the court everything about what happened. It doesn't work that way in unlawful detainer court. You generally get anywhere between 2 minutes and maybe 10. So the majority of your day is spent waiting around for your case to be called. After the hearing, if the landlord wins, then after the hearing, if the landlord wins, it's not over. So with this contested trial, you have to go through this entire process of filing the unlawful detainer. You have to wait in court all day and follow the rules of the clerk and present your case. After the hearing, you'd think that if you win, it would be over. It's not. There are additional documents that you have to file with the court after your contested hearing. The landlord would have to obtain a judgment of possession. That's a document that you draft, prepare, send to the clerk sends it to the judge, and then the judge stamps it and sends it to you. That process doesn't happen on the same day as your contested trial. Your case will continue to go on until you get these documents. You have to wait for the clerk to issue a writ of execution. Your writ of execution is the document, same process. You prepare the document, send it to the clerk, send it to the judge signs it and sends it back to you, and again, that doesn't happen the same day either. But the writ of execution is what allows you to have the sheriff have the documentation that they need to actually go to the tenant's property to actually evict the tenant and lock the tenant out. If the tenant wins, it's not over that day either. Your contested trial, you may think, is over, but it's not. The tenant may get to stay. The judge may make an order that they get costs or fees. So the stipulated judgment is an alternative. Let's talk about what it is. It's an agreement. It's an agreement that you reach with the other party. It's placed in writing, and it is approved by the court on the day of the unlawful detainer action. It's a way that you can completely resolve your unlawful detainer action on the same day. You know exactly what the terms are, and you're set. With the stipulated judgment in this particular writing, you pick the terms of it. You pick the terms of it. It takes as long as you want it to take. If you want to negotiate with a person for 5 minutes and you come up with the terms, then there they are. If you take an hour to go over the terms of the agreement, you can do that. Once the stipulation judgment is drafted, it's a document that you write outside of the courthouse, it takes priority over all of the other unlawful detainer cases. Once the court sees that you have a stipulated judgment, your case takes priority, they call you, they stamp your order, and you're out of there. What a stipulated judgment can secure. You can save money on legal fees, you're in and out of court, everybody loves that idea. A lease termination, you have an actual termination date. A payment plan, if the tenant owes money, you have a payment plan. A determined move-out date. You know exactly when the tenant is going to leave. Avoidance of appeal. Again, we can have a different presentation on appeal because that's another long, litigious process. Stipulated judgment can secure all of these things as opposed to proceeding with the contested trial. All right, so the last thing I think every landlord needs to know, and we all know this, it's just a reminder. It's just humanism, personability, just Develop a good rapport with your tenants. Establish a positive relationship. When you have a positive relationship with your tenants, such a simple reminder, they'll have benefits through your tenancy. They'll be more likely to take care of your property. Benefits through the eviction process. If you've maintained a positive relationship with your tenants, the entire tenancy, then it makes the meet and confer process to prepare the stipulated judgment go a whole lot easier. Estelle and Kennedy, we provide 15-minute free telephonic consultations. This is our team last year, this is our team this year. And I want to say thank you to Ben and also the entire commercial real estate committee for giving me time today.
Thank you.